Can advocates work with victims who have a guardian?
Yes, advocates can work with victims who have a guardian. The question will be very specific both to local state law and also to what are the powers of the guardian. So as I mentioned before, a guardian doesn't necessarily tell us everything about what that person's powers are. Knowing that someone has a guardian tells us that a court has ordered that there is something in their life that another person has control over. It is possible that the guardianship is very limited, and it's also possible that there are some joint powers. So there are some things that a court can order that both the guardian and the ward either decide together or decide independently, and it's important to know what that is. But I think it's also important for advocates to have a clear sense of what are the services that you're providing, and you have to make a decision under your local laws. If somebody comes to you who has a full guardian, if the service that you're providing is listening, providing information, being supportive, and assisting people to sort out how they want to talk about and take action about their own situation, then that very well may be a totally appropriate service for you to provide for somebody, regardless of whether they have the legal authority to consent to anything. It's, if somebody comes to you and they want you to listen, I think you have the ability to listen, regardless of whether someone has a guardian or not.
How about a situation in which a guardian or conservator had been assigned? Is an advocate able to continue working with a victim in those circumstances?
Absolutely. The first thing that I would want to assess as an advocate is whether that guardian is acting in the best interest of the client. Is a guardian in good faith? We certainly see cases where the guardian themselves is the perpetrator of violence or exploitation, and so I would want to be alert to that possibility and do a real assessment of whether there is any sort of coercive control going on in that relationship. There, of course, it's a guardianship, so there's going to be some level of control. That's the nature of the relationship. But just to try to identify whether there's a problematic relationship there first. Once you've established that the guardian is acting in good faith on behalf of the client, then absolutely it's perfectly fine to continue to work with the client and with the guardian together to try to do safety planning, to access resources. All of those things would be perfectly acceptable.